in our last two session, the one on return. Before starting, I have to say that we found a phone. So if you miss your phone, and probably you know that, please go to Nicole Bosmans. She keeps it and will give it back. So I am today chairing this meeting because our colleague Jean-Yves Carlier is unfortunately sick. He was supposed to be replaced by our colleague from the Netherlands, Tesseltje de Lange, and she got sick also. So I am not yet sick, and I will chair this session on return with a panel you can see in the program. We will have first a duo, two speakers about the asylum procedure regulation, one speaking about the types of procedure. Do we have a common procedure? Jens Vedsted Hansen, who is a well-known specialist of refugee law from Denmark, an emeritus professor from the University of Aarhus. And then we will have a second presentation by Vincent Chetaille, whom you probably know because he's one of the rare specialists of, in particular, international migration law, but he's also interested by the procedural guarantees for asylum seekers during the return procedure. Then we will have another presentation by Barbara Mikolajczyk from Poland, and she will address the issue of legal advice, legal representation, but then this new concept of legal counseling. And then we will have two persons making comments. We have with us Fabienne. I have always difficulties to pronounce your name. Okay. And she represents UNHCR. And of course, it's always a key institutions about refugee law. And then we have also the pleasure to have with us Thomas Bonbois, who is, I think it's best to say it in French because translation is not very good. He is a référendaire at the Court of Justice of the European Union, and he follows very closely the case law of the court. And so he will give us, we will have the privilege to listen to him by making comments about the new rules on asylum procedures. And let's start immediately. Jens, the floor is yours. You can speak here or there, as you want. That's you make your choice.
Thank you very much, Philippe. Thank you for welcoming us and thank you for inviting me. I think I'll stay here because I need my notes. I'm going to answer a question which cannot be answered really. As with many of the topics of this conference, we are in a kind of forecasting stage, just like meteorological science, the weather forecasts are somehow impacted or made uncertain by climate change and other things, and it's exactly the same here. Thank you. So, okay, good. So I'm going to make some qualified guesses, I would say, and then towards the end, if time allows, I may have another observation on weather forecasts. When the Commission more than 8 years ago set out proposing changes to the EU procedure standards, it had very high aspirations. Not only was it proposing a regulation also here, which of course in itself, due to its direct applicability, would imply a stronger degree of harmonization. There were also sort of more substantive aspirations. I have made a few quotes here. I'm not going to read them out, but it was very clear from the explanatory memorandum of the proposal in 2016 that the Commission wanted a even to ensure full convergence between member states' asylum procedure systems. So what happened? As we all know, the Commission amended its proposal in 2020 in light of negotiations and as part of the legislative package that accompanied the Migration Pact, Asylum Migration Pact in 2020. Then we had the negotiations within the Council, within the EP, and between the two. And finally, I think forecasts are being complicated by certain distorting elements in the procedure regulation. Finally, ultimately, we have some recent calls for so-called innovative solutions and even unilateral actions that make any forecasts plainly impossible. First, about the contents of the asylum procedure regulation. Much of the focus was on asylum border procedures. And here, of course, this instrument has to be seen in connection with two other, the screening regulation and the return border procedure regulation. The question that caused quite some controversy in the Council was whether asylum border procedures should be mandatory or optional. The compromise was struck by the Commission in the amended 2020 proposal, which was in that regard largely followed actually in the adopted regulation. As a main rule, asylum border procedure would remain optional, but there were important exceptions introduced. The border procedure would be mandatory in 3 types of accelerated examination situations by a very sort of complicated or convoluted reference system between the articles of the regulation. I'm not going to quote them here, but the 3 situations in which accelerated examination was to be mandatory and in which that examination would have to take place in the border procedure were applicants considered to be misleading the authorities, applicants considered to be dangerous to national security or public order, and thirdly, those coming within the novelty acceleration ground of people coming from a country for which the average recognition rate is 20% or lower. This in itself might call for some uncertainties as regards the degree of harmonization, because we have a main rule optional, an exception or 3 exceptions for mandatory asylum border procedures. And these procedures, accelerated and border, are located in a part of the regulation which is about special procedures. Let me make it clear that special procedures do not in and of themselves neither enhance nor decrease harmonization. And having special procedures is not the same as having derogations or exceptions, optional provisions, and so on. So that term in itself says nothing about the degree of harmonization, I would say. But there are some things in the regulatory context which may impact harmonization. Some factors are enhancing it. Of course, mandatory screening at the external borders may impact also the degree of harmonization of asylum procedures, or it may not. I have been arguing ever since the proposal in 2020 that this mandatory pre-entry screening may potentially be merging with asylum border procedures. That depends on member states' procedural autonomy. So therefore, it may potentially actually deharmonize. It may also enhance harmonization. Who knows? It's not to be forecasted on the basis of the written rules, so to say. Secondly, we have the mandatory asylum border procedure once again, of course, in itself enhancing harmonization. And then, in addition, we have mandatory return decisions in the asylum procedure regulation, and in addition, we have the separate instrument on mandatory return border procedures. So all of this is in theory at least, able to enhance the degree of harmonization. Then, during the late parts of the negotiations, the Asylum Procedure Regulation was amended by introducing a number of articles on the adequate capacity relating to the capacity of member states to have border procedures, asylum border procedures. I'm not able to explain the details of these provisions, so I'm not going to bother you with that. I have an idea of what they basically mean, but it's more or less mathematical, and I would say that they are simply misplaced in this instrument. If such a thing should be there, which was apparently the legislators' will, it should, in my modest view, have been placed rather in the asylum and migration management regulation, because it has basically nothing to do with rights, obligations, principles for the individual asylum procedure. And also when it comes to forecasting the degree of harmonization, I would say that this adequate capacity notion is distorting. In itself, it has nothing to do with substantial harmonization, but it may significantly impact the incentives of member states in the sense that member states may sort of use the adequate capacity as a kind of point of reference as to the extent to which they need to have or want to have asylum border procedure operating. Of course, they need to have it in the mandatory situations. On the other hand, they may not have to do it anyway if they have reached their adequate capacity. At the same time, if they have their adequate capacity in place and it is not being sort of utilized fully for mandatory asylum border procedure cases, then it may enhance their incentive or create the incentives for the application of the optional asylum border procedure, altogether making the allocation of cases and the application of border procedure uncertain, so to say, for factors which are beyond the nature of cases and not necessarily taking the procedural safeguards of applicants into account. Then the next element to be taken into account here is the accelerated examination procedure. In itself, this is, of course, a huge step towards harmonization, because previously in the Asylum Procedures Directive, acceleration of the examination procedure was mandatory. Now it is, sorry, it was optional, of course. Now, under the regulation, it is mandatory that apart from two of the listed grounds for acceleration, the cases listed in the relevant provision have to be examined in the accelerated examination procedure. It is mainly mandatory. And in addition, it has to be applied in the context of the asylum border procedure under the mandatory provisions I already mentioned. If applicants have been or are considered to have been misleading the authorities, if they're considered to be dangerous, and thirdly, if they come from a country with an average recognition rate of 20% or lower. I could question, as I have done on various occasions, this new acceleration ground. We may come back to it in the discussion. I'm just pointing to the fact that it is in itself a kind of anomaly to have it, because it is, of course, for necessary reasons, combined with exceptions, which makes it a kind of contradiction in terms to put it in the context of the accelerated examination procedure. But anyway, acceleration as such is clearly a part of the instrument which is enhancing harmonization. Then, on the other hand, there may be some deharmonization caused by the notion of prioritization. We knew that already from the Asylum Procedures Directive, where member states had the possibility, which they would have anyway, I guess, to prioritize certain cases if there were particular concerns relating to the applicants, if they had well-founded cases, if they were vulnerable. In the new regulation, this has become different. It is emphasized that this is up to member states' flexibility to apply the prioritized examination procedure And in addition, the regulation is also mentioning examples of prioritization, which are not sort of inspired by concerns over the applicant, but rather over the member state interests. So it's somehow merging in an unclear manner with the acceleration grounds. Altogether, I would say that the acceleration of asylum procedures is certainly a factor that will enhance harmonization. Finally, we have, of course, also importantly, the phenomenon of admissibility decisions. And here again, we have sort of factors pointing in different directions. I think we could consider the provisions on admissibility decisions, the inadmissibility grounds and the procedural rules governing admissibility decisions to be a kind of hybrid of optional and mandatory standards. As such, the inadmissibility grounds or decisions are optional. Grounds are optional. Member states may consider certain applications inadmissible. Maybe this is a phenomenon which will be harmonized anyway, because there will be a strong incentive towards avoiding examination on the merits if it is possible to reject a case as inadmissible. Secondly, the application of the asylum border procedure, which would be the logical context, of course, for such decisions, is actually also optional. But here again, the climate, the regulatory context comes in and may, in practice, I guess, enhance harmonization, because inadmissibility decisions will be logically linked to the pre-screening and the detention considered to be, or at least the limitations of liberty of movement, which are considered to be the intended results of the pre-screening of irregular arrivals at the external borders. That will sort of make it very logical and convenient to also consider inadmissibility in the same context, enhancing harmonization, I would say. Then finally, about admissibility decisions, we have the rules on safe third countries, which could be considered quasi-mandatory. Again, we have a kind of hybrid here. The rules, the grounds for considering a country as a safe third country are, in one way, they are mandatory, but based on a vague notion of effective protection. But I think it carries strong presumptions of safety, so I would say that these are at least quasi-mandatory rules. And then finally, we have the connection requirement, the very controversial element of the safe third country concept, which was retained, a little bit watered down, but still retained as a compromise in the adopted regulation, but with the proviso that it's going to become potentially revised already after a year. So we have sort of both a present and a future for the connection requirement. And the future sort of leads me to talking a bit about forecast then. I mean, more recently, we have all sorts of initiatives. We had the day after the adoption of the legislative package, the 15th of May, a number of member states, including my own, which is, by the way, common European asylum system anyway, sent this famous letter to whoever, the Commission, I guess, asking for innovative solutions, which was a kind of opening the debate over the instruments once again, or maybe just taking sort of opening the debate at least over the safe third country concept and the effective protection notion, which is crucial towards some of these innovative solutions. These are the ones I know from my own government, and we see them spreading around now. If the connection requirements get away, and if, depending on how the effective protection notion and the concept of safe third country are going to be interpreted, it may effectively open the road towards the Lex Wanda solution, as we have it in place in my country. The UK had it in place and we see it spreading. So that will depend exactly on these rules. And then finally about the climate, the regulatory and political climate, which makes things extremely uncertain. We see now not only these calls for innovative solutions, but also declarations of disobedience from some member states. And that altogether makes it very uncertain whether harmonization is going to take place at all. Because we have seen for the past number of years that as long as the content of legislation is up in the air, then there will be some reluctance in enforcing it. We have seen that, and there were hopes that now, since the legislation was in place in May this year, now the Commission and the Court could start enforcing and interpreting. But at least the Commission may become uncertain, because if things are now being renegotiated and important member states declare their preparedness to act unlawfully anyway, then it may make harmonization a kind of a town in Siberia or something far away. So it's very difficult to talk about the likelihood and the degree of harmonization, really. It depends so much on the climate, just like the weather forecast. Thank you.
Of just here now whether the regulation has achieved the objective of harmonization remains disputable. And I will bring another dimension, in the sense that there is another parameter here, which is quite well known. Asylum procedures have been designed here to serve more as a tool of migration control than a tool of protection. And this strategy is not new. It has been well documented by many colleagues here in the room, and this strategy has been exacerbated arguably in the pact, and despite many warnings from UN special rapporteurs, UNHCR, civil society, and so on. And clearly, the risk, obviously, is to undermine and jeopardize the right to seek asylum and the principle of non-refoulement. And the starting point of such analysis will be the fact that summary rejection of asylum claim has become the new normal through the generalization of accelerated procedures and border procedures. So, of course, there is a core common content of procedural guarantees, but there is a huge risk of double standards first, and of course of poor implementation on the ground. So the new normal, summary rejection is mainly based on an expanded use of the border procedure, which represents the most striking characteristic of the new regulation, alongside the banalization of inadmissible grounds and accelerated procedure. So the border procedure has been already mentioned several times, so I will be relatively short, but it will clearly become the rule for the vast majority of asylum seekers in Europe. And this border procedure has a quite broad scope of application and quite strong consequences for asylum seekers. So regarding the scope, this is mentioned here in Article 43. Interestingly and quite ironically, the border procedure is not limited to the border. The border procedure is not limited to applications made at the external border or in transit zone. It may also apply to anyone who is apprehended for having crossed an external border irregularly, even if the person is actually very far from the border. So you can be intercepted in Brussels, Paris, and Berlin, but still then subjected to border procedure. So instead of border procedure, this is more about irregular entry procedure. And here this is an issue. And perhaps this notion of irregular entry procedure has not been used because obviously there is clearly an issue regarding Article 31 of the Refugee Convention. So clearly, the border procedure has the potential to be extensively used. And as mentioned by Jens before, there is a subtle distinction between mandatory grounds and optional ones. It is, however, quite likely that most member states will use both of them on a systematic basis in order to reinforce these ideas that border procedure will be the most normal way to assess asylum requests. And following the typical logic of migration control, most applicants are supposed to be detained or if not put in centers or deprivation or restriction of liberty as exposed yesterday, the gray zone between the two. And of course, this is further exacerbated by the fiction of non-entry we discussed yesterday. Another interesting and important element is the automatic denial of protection. So whether submitted at the border or not, asylum applications may be rejected as being considered inadmissible in several circumstances listed in Article 38, you have just there. And these circumstances include the very controversial grounds of safe third country. And we all know how this notion is at the heart of the new strategy put in place in the pact. And the legality of this notion remains debatable. As such, and there are some major ambiguities here regarding the Article 57. We, in the sense that according to Article 57, the so-called safe third country does not need to be part of the Refugee Convention as such, and this is an issue on its own. Whereas, and here there is an interesting hiatus because the notion of effective protection can be conceived and implemented even for non-state parties, whereas the definition of safe third country is including protection from refoulement under the Geneva Convention. So this is quite strange as such, and clearly there is a room here for not only ambiguity, but disputable practice on the ground. Again, this notion has been extensively discussed, so I will not continue. I would like to focus on another issue which we did not discuss a lot because applications shall not be examined on the merits when an application is explicitly or implicitly withdrawn. So explicit withdrawal is mentioned in Article 40 and does not raise major questions, but implicit withdrawal is more problematic as such because this means that an application is implicitly withdrawn in cases involving lack of cooperation from asylum seekers, or if the asylum seeker fails to lodge an application or attend a personal interview without good cause. And here this is an issue from the angle of international law, because denying protection on such a ground without even assessing whether the person is or not a refugee is a violation of the Geneva Convention. The lack of cooperation can be part of the picture as such, but the lack of cooperation or failure to attend an interview have nothing to do about the fear of being persecuted. So you can be in these circumstances even if you are a refugee under the Geneva Convention. So this is here a relatively worrisome element in the pact. Another element which has been already mentioned is the extensive use of accelerated procedures. So, and this is one of the greatest changes of the regulation. And also because it does include vague and subjective situations in which the applicants are deemed to have only raised issues that are not relevant, made false and contradictory allegations. So the idea here is as if there is a presumption of bad faith and use presumption of rejection. It's not fundamentally new. We know that it was already the case before, but this is still a very disputable notion. And the same presumption of rejection applies when the applicant has not made an application as soon as possible, and also in the situation of safe country of origin. So, in fact, everything here is in place to ensure a quick and summary rejection of asylum applications. Of course, on the paper, you can always discuss about, because the wording is sophisticated enough to avoid the blatant objection under international law, but clearly we can see here the project, the purpose, and also the ambiguity given rise to discretion of the state, and accordingly a debatable practice. That being said, there is still a common core content of procedural guarantees as such. And here the issue is less, the guarantees are quite important. As always, of course, the devil is in the details. So, and some guarantees allows derogation, exceptions for border procedures, accelerated procedure, inadmissible rejection. And clearly here you can see the risk. But overall, it's true that this is not, they are not the most debatable notions. We have here the right to be informed, which is well acknowledged as such, including detention center, but with a disputable formulation, which has been criticized by UNHCR, ECRI, and many others, in the sense that the applicant can be informed in a language which they are reasonably supposed to understand. And this formulation, which was already in the previous version, has raised many difficulties in practice as such. But overall, it remains that the right to information, despite this, is quite well acknowledged as such. Assistance during the procedure will be developed by my colleagues. And there is also an important provision of the role of UNHCR, and I'm sure that the colleague from UNHCR will also discuss this, because this is an important safeguard on its own. Similarly, the right to an interview is also well acknowledged, in the sense that the regulation establishes different kinds of personal interviews during the asylum procedure. But here again, then, these interviews may be omitted in some situations listed in Article 13, and including when the national authority considers the application inadmissible on the basis of the available evidence. So here again, the principles are important and clearly in line with the basic values and guarantees of EU law, but there is a room for exceptions, derogations in case of inadmissible. And the same, so generally speaking, the two key patterns are the risk that the border and accelerated procedures will not only become the rule, but they will also derogate from the ordinary procedures, and notably on two elements regarding the time limit. Under the regular procedure, applicants have 21 days from registration to launch the application, but for border procedure, this is only 5 days. And this duration of 5 days has been already criticized by the European Court of Human Rights. So clearly here, there is another issue regarding border procedures. The entire border procedure must be completed as quickly as possible and not later than 12 weeks from the registration, and which is quite a challenge because even today, member states are not able to complete the procedure within 6 months. So how can they do in 12 weeks, whereas they are not able to do it in 6 months? This is another issue. And another important element to be put on the table of the discussions are the suspensive effects. So here again, the principle is clearly in line with human rights law. So applicants shall have the right to remain on the member state territory until the time limit for appeal has expired. However, Article 68, paragraph 3 excludes suspensive effects in case where the application was examined under asylum procedure or rejected as inadmissible. And clearly here, the lack of automatic suspensive effect is clearly an issue because the regulation still mentions that they must be protected from refoulement, but here again, there is no automatic suspensive effect as it is not normally required by the European Court of Human Rights and many others. So to conclude, there are a typical ambiguity which is not fundamentally new between principles and exceptions. And the risk is that the exceptions will become the principles, especially in our the current political context. And the gap has never been so huge between law and practice at the external border since the last decade. And the risk here is that the new regulation may transform this gap into a gulf at the expense of refugee rights. So, of course, there are common standards, common guarantees, which are important, but the regulations grant national authorities a broad discretion and allows for many exceptions and special procedures. And clearly, the risk of all these elements is no longer a risk because it is already a reality in the sense that the asylum procedure is becoming a tool of exclusion more than a tool of protection. And this is, when combined to all the many measures we discussed since yesterday, something which is particularly worrisome for the due respect for the refugee rights. Thank you very much for your attention.
We are now having another presentation of Barbara on legal aid and legal counseling.
At the time Does it work?
Yeah, it's working.
Just this one.
Is in there, so
Okay.
just.
Okay. Oh, sorry. Oh, I hope that. Sorry, there is a lot of things to say. So, thank you very much for inviting me to share some thoughts about legal aid for asylum seekers in the new pact. It is a very complex issue, so and a lot of provisions are spread over all the pact. So I have selected some aspects. My idea is to show you two faces, the angel and the devil of legal aid in the pact. So let's go to the asylum procedure regulation, which appears the principal instrument for providing legal aid for asylum seekers. And let's check if there is any improvements compared with the procedure directive. So we can observe that the most important changes refer to free legal aid in the first instance. The new regulation mandates that applicants receive information. It was said just a few minutes ago, receive information about the right to free legal counseling, assistance, and representation. Asylum seekers may obtain these forms of legal aid on their request. Free legal counseling at the pre-court level should be granted as soon as possible after an application for international protection has been registered. States may also provide legal assistance and representation in the first instance, but it is not mandatory. However, everything depends on a practical solution. Just we can imagine the example. It would be logical that a legal counselor should be appointed to the asylum seekers before they lodge their applications. So it should happen between registration and lodging the applications. But in practice, both these actions can be performed at the same time. So when a counselor will have the time to know the case and know the applicant. So how to organize the counseling in such a situation, especially somewhere in the border or closed zones, etc. So it is one of many practical challenges, and nobody knows what the future brings. The new regulation assumes that in each EU state, the proceedings at the first instance, in the first instance, will be administrative. So this solution should be assessed as an improvement. It tends to unify national procedures and connects asylum procedure with Article 41 of the Charter of Fundamental Rights, the right to good administration. Another advance is improvement of the quality of legal aid. A legal advisor or counselor should be permitted or accredited, permitted or admitted under national law, and NGOs should be accredited to provide legal aid for asylum seekers. On the other hand, there is also the mysterious and trusted person who can provide counseling for several applicants at the same time. So may lower the level of the quality standard of the legal aid. So it may therefore be, for example, an employee of the registration body or authority considering the case. The regulation does not prohibit conflict of interests between an asylum seeker and the entrusted person. Such prohibition would not be anything unusual because we can find such prohibition in the new reception directive. The second instance mainly remains unchanged. Asylum seekers can receive free legal assistance and representation on request. However, there is also there are also higher requirements for legal advisors. In both instances, restrictions and limits in providing legal aid have remained. However, exclusion of free legal assistance and representation has been added in the case of abusive application. Moreover, the premise of not favoring asylum seekers over nationals has been moved from the first instance to the second instance, what is reasonable and it should act in favor of foreigners. The regulation defines free legal counseling, assistance, and representation. Let's look at the novelty. The free legal counseling covers assistance with applying for international protection, the guidelines on how the asylum procedure works, on different types of procedures, admissibility rules, and on each issue which can arise during the procedure. So it is much more than legal information. It is notable improvement over the directive, which only requires states to provide limited information on request. So free legal counseling is a leap to a higher level, and it is the bright side of the pact. But let's go to the dark side of the pact. Okay, so I have selected some risks to providing legal aid. For example, there are restrictive deadlines in border procedures. Such situation does not foster providing legal aid. The wording of, we know that Dublin never dies. So the wording of Article 21, 20, 21 and 22 of the management regulation shows that legal aid, legal counseling is limited to the Dublin criteria. So I'm not sure if an applicant who fell into this procedure can receive full information and counseling covering the whole asylum application process. So maybe he or she receives only just the piece of it. So in the return border procedure, the border return the regulation on the border return procedure excludes the most important provision, which is contained in the return directive. It is Article 13. It refers to many provisions of the return directive, but Article 13 about legal support is excluded. Of course, there are possible restrictions in access to documents and information due to the public order and security, and similarly, there are possible restrictions of NGOs and advisors in access to closed zones detention. And it should be noted that the restriction based on the requirements of administrative management may be interpreted very broadly. Administrative management, it may be everything. So finally, the possibility of suspending safeguards in the situation of mass influx of migrants seems always dangerous from the human rights perspective. So let's go to the conclusion. So I hope that I am on time. There are two phases of the pact regarding the legal aid. The pact should be considered as an improvement, especially due to introduction of legal counseling in administrative procedures. It connects the asylum procedure with the right to good administration, and the requirement of higher quality of legal aid is also an advantage. However, for the applicant, there is a long way to go before he or she falls into the administrative procedure. It may become symbolic. Bojdar said yesterday about symbolic instruments. In fact, the devil devil is in details and outside the regular asylum procedure. Many risks to effective legal aid arise from the complexity and general the whole nature of the pact. The main problems arise in connection with the fiction of no entry, detention, closed zones, accelerated procedures, etc. The multiplicity of bodies registering, considering, deciding on transfer does not help in understanding the whole system. Finally, the pact still allows states a high degree of discretion, so the implementation is in states' hands. The will of states and their practice possibilities will be principal here. So probably all the monitoring bodies, UNHCR and other will hands full with work. And finally, the future European Court's ruling probably will disclose various deficits of the pact in the area of legal aid. Thank you very much.
Now we are going to listen to Thomas Renvoy from the Court of Justice.
After having warmly thanked the organizers of this conference for their invitation, I would like to share with you three sets of thoughts triggered by this morning's excellent presentation. Three sets of thoughts related to the three major players in the interpretation and application of the new regulation, new procedure regulation. These players being first the Court of Justice, second the national administrative authorities, and last the national jurisdictions. Let me clarify from the outset that I'm speaking here, of course, in a personal capacity and not on the court's behalf. Let us start with two considerations about the Court of Justice and the new procedure regulation. In the first place, and as far as I know, no action for annulment has been lodged against that regulation. It is therefore essentially by way of references for preliminary rulings that the court will be called upon to rule on the scope of the procedure regulation. And in that regard, it should be noted that during the last judicial year, no less than 25% of the asylum cases brought before the court were handled by its grand chamber. And for me, this is a tangible proof. The Court of Justice is fully aware of the importance of asylum litigation for the construction of a European area of security, freedom, and justice. And I have little doubt that this trend will be confirmed and even perhaps accentuated with the entry into force of the regulations implementing the Asylum and Migration Pact. In the second place, several speakers highlighted this morning the existence of provisions in the procedure regulation laying down general guarantees for asylum seekers. For my part, I would refrain from regarding this provision as mere programmatic exhortations that will be in practice necessarily undermined by the more specific provisions of that regulation. I believe, on the contrary, that these general provisions should be treated for what they are: cross-cutting provisions establishing fundamental principles that should guide the interpretation by the Court of Justice of the entire system established by the procedure regulation. And in this respect, the case law of the court, again, seems to me to be very explicit. Consider, for example, the importance attached by the court to Article 5 of the Return Directive or Article 6 or 46 of the Procedure Directive. I see little reason why it should be any different in relation to the provisions of the new regulation laying down general principles and guarantees. Let us move on, if you agree, to my second set of thoughts about the way national administrative authorities will have to apply the new procedure regulation. And I would like to share with you 2 or 3 considerations regarding, on the one hand, the inadmissibility decisions, and on the other, the border procedure. Firstly, it follows from Article 55 of the new regulation that national administrative authorities must, not may, must reject a subsequent application as inadmissible, where, in essence, the applicant failed to provide all the relevant information during his first application. However, these new provisions should still be interpreted in accordance with the case law of the court. And in that regard, the court recently recalled that the subsequent application cannot be considered as inadmissible, where the rejection of the first asylum application was contrary to EU law. Furthermore, according to the court, an applicant cannot be blamed for not having invoked during his first asylum procedure an existing judgment of the court, which should have prevented his first application from being rejected. Secondly, according to Article 57 of the Procedure Regulation, a national administrative authority may reject an application as inadmissible if the applicant can reach a safe third country, even though it cannot lodge an asylum application in this third country. Does Article 18 of the Charter, guaranteeing the fundamental right to asylum for persecuted person, read in conjunction with Article 52 of the Charter, authorizing some limitations to fundamental rights, do these articles enable a member state to refuse to examine an asylum application because the applicant can return to a third country where he certainly is not at risk of persecution, but where he cannot obtain refugee status either? It's a question worth asking, although I will certainly refrain from answering it today. My last comment concerns the application by national administrative authorities of the border procedure. On reading Article 53 of the procedure regulation, it is clear that the EU legislator has taken care to learn from the case law of the Court of Justice about the Hungarian transit zones in Tompa and Roszke. More specifically, particular attention has been paid to the distinction that has to be made between detention measures, which constitute a truly deprivation of liberty, and measures which merely restrict the applicant's freedom of movement. It will therefore be crucial to identify in each case whether the third country national whose application will be examined at the border are or not subject to detention. If they are, all the guarantees associated with deprivation of liberty must be applied to them, including the obligation for the judge to carry out an own motion review of these guarantees, as the court specified in a judgment of November 2022, Staatssecretaris van Justitie en Veiligheid. Furthermore, it is true that Article 51 of the new procedure regulation stipulates that applications at the borders must be lodged no later than 5 days after their registration, and the brevity of this deadline has been criticized. However, the regulation also specifies that this time limit only applies insofar as the applicant is given an effective opportunity to lodge his application within the time limit. And this clarification seems to me essential. It aims to respect the principle repeatedly highlighted by the Court of Justice and confirmed by recitals 13 and 14 of the new procedure regulation, the principle according to which the objective of the EU legislator is to guarantee an easy and effective access to the procedure for obtaining international protection. Member states must therefore guarantee such an effective access to the procedure even at the borders. I would like to finish with 2 brief considerations related to the interactions between the new procedure regulation and national jurisdictions. Firstly, I would like to draw your attention to a very recent judgment of the court delivered on the 4th of October this year in the case 406/22 and interpreting Article 47 of the Charter. For the court, this Article 47 implies that the competent national jurisdiction must raise of its own motion the violation of at least some procedural guarantees afforded to applicants by the procedure directive and in the future by the procedure regulation, even where that applicant has not invoked such a violation before that jurisdiction. Therefore, national court must review motu proprio, at least partially, the legality of rejection decisions. For me, the importance of this recent judgment for the protection of asylum seekers' procedural rights cannot be underestimated. Secondly, it is true that according to the procedure regulation, not all applicants are systematically granted the right to remain on the territory of the Union once their application has been rejected and its firm decision has been adopted against them. However, it should not be forgotten that according to the court's case law since the Gnandi judgment, an appeal against such a return decision must have an automatic suspensive effect where the return of the third country national may expose him to a risk of inhuman or degrading treatment. Therefore, even in cases where the right to remain on the territory of the Union is not guaranteed by the new procedure regulation, there is still a safeguard in the Charter against the risk of violation of the principle of non-refoulement. My conclusion will take the form of a question. More precisely, the question that the High Court of Ireland recently referred to the court in case 97/24, and which seems to me to transcend all our discussions. Can a member state escape its obligation to compensate the damages suffered by an applicant for international protection who has not been protected as required by EU law, by invoking as a case of force majeure the massive influx of applicants into its territory? I note that in its defense before the Irish jurisdiction, the Irish government argued that the Migration Asylum Pact demonstrates the European institutions' awareness of the need for a better distribution of applicants between member states. There is no doubt that the court's answer to this preliminary ruling will be of interest to all of us, not only as lawyers, but also as citizens. I thank you for your attention.
Good morning, dear colleagues. Thank you. I'll share with you 4 points of reflections on the issues that we discussed today already, but also yesterday. And I'd like to start with a bit of a general one, and that concerns refugee inclusion in policymaking, including when it comes to procedures. So we tend to often have these very technical discussions about flows, worse about illegal flows. We talk about certain percentages going there, 10% here, 30,000 places for border procedures. So a lot of numbers, a lot of stats. So there's this monumental effort to try to control something, which by very nature is very difficult to control. And what I feel it blurs sometimes is what we're talking about is people. And these people have agency and should be able to exercise that agency. And we, as working in this field, would be very well advised to take this into account, that people also take their fate into their own hands. And if I may add, who can blame them? If I'm the mother, if I'm a Syrian mother of 4 children whose daughters experience sexual violence in the streets of Bulgaria because Bulgaria doesn't, in Sofia, because Bulgaria doesn't provide safe reception standards, or if I'm the father of a family whose child gets run over by a train because Croatia just pushed us back from the Croatian-Serbian border, or if I'm someone who loses a limb due to frostbites at the Polish-Belarusian border because there's some kind of cruel ping pong going on between the Belarusian and Polish border guards, would I just sit there and wait until EU pressure and EU money somehow perhaps changes the situation on the ground? No, I'm a mother of 2 and I would try to get my kids out of harm's way. So I apologize for these maybe very general intro remarks, but I think really we should be aware that we can put into place all the deterrent and punitive sanction measures, some of which were mentioned today, and yesterday. All we want, if we don't take into account why persons do what they do, this will not be effective. And in that sense, I would like to mention also, because it came up in discussions yesterday and also last week, that it seems to be that there's a good practice here in Belgium where so-called refugee committees have been formed. There's others in this room who know much, much more about this than I do. And I know we have some of the leaders of the refugee committees here with us. So please get in touch with them if you want to know more about it. But it seems to us in UNHCR that there's a lot that we can also learn from such community-based services and protection, especially where state protection and services fail. So now I come to the much more technical legal comments, also building on some of what my colleagues have said. And I should add that UNHCR has published very detailed comments on the original asylum procedures regulation proposal. So there you find all the technical positions, also on implicit withdrawal, as was mentioned today, acceleration grounds, timelines, and so on. I'll just mention very few today. And one that I wanted to mention is safe country concepts, because that, of course, has been one of the key aspects, one of the most controversial aspects, specifically the safe third country concept. From UNHCR's point of view, we've made it clear from the very beginning that what we do not want to see is a systematic mandatory rejection regime, in essence, which shifts responsibilities from the EU towards countries which are often less well placed to assess applications. And that is not only for legal reasons, but also for practical reasons. And here, the entire debate about a connection requirement, yes or no, here there's also very important practical reasons for why UNHCR has for a very long time and consistently advocated that such a connection between the applicant and the third country, a connection which makes it reasonable for the applicant to go to that third country, is a good idea. And legally speaking, we didn't have the time, I guess, to go into all of the Luxembourg case law on this, but under the APD, we have very detailed good jurisprudence where the CGU ruled mere transit cannot be considered a connection, because otherwise all the rules that we have on challenging a connection would be, and I quote, devoid of any purpose, end quote. Of course, under EU law, there's always a requirement for an individual assessment of safety, a case-by-case analysis in depth, whether the third country would be safe for a particular applicant. The applicant must evidently, and we just heard how the Court of Justice has really emphasized procedural guarantees and the right to an effective remedy. Evidently, the applicant must be able to effectively rebut any presumption of safety and also challenge the existence of a connection. And courts must rigorously examine whether each of these conditions are fulfilled, and to ensure that the person has an opportunity also to set out the views in person. And we also have Strasbourg case law on this, and I should say UNHCR has in several interventions before both of these courts argued those points. And you find UNHCR's interventions before court, so before the Strasbourg court and the Luxembourg court, online. They're all public. You just Google if you're interested, UNHCR CGU, UNHCR ECTHR. And that brings me to the third point that I wanted to make on judicial guarantees. What we felt in the whole discussion around the pact for the past almost a decade, the pact not for a decade, but the initial set of proposals by the Commission have been proposed like almost a decade ago. And in those discussions, we felt there's a very worrying trend of trying to limit access to courts, access to appeals. Very often, appeals are seen as the problem. But sorry to say something perhaps evident, but it's not the appeals that are the problem. It's not the appeals that are clogging asylum systems. It's the reasons for why many asylum seekers have very good reasons and are successfully appealing. So appalling reception conditions, flagrant violations on rules that are supposed to ensure access, manifest errors in applying EU law, including the rules that give rise to the Refugee Convention grounds, lack of proper interpretation, lack of legal aid. There's a huge manifold array of reasons, and Esther Pozo has recalled this yesterday. She said all member states have something to do, some in reception, some in procedures, and so on. So let us honor this right to an effective remedy, let it defend it, rather than creating this idea that it's the endless appeals that just clog asylum seekers and prevent the conclusion of asylum determination. And in that sense, and maybe going a bit more technical, the whole issue of automatic suspensive effect, we agree with the concern that was raised also yesterday by Galina Collis, that a lack of automatic suspensive effect in especially border procedures can significantly raise the risk of practices contrary to the principle of non-refoulement, especially at borders. And that is something we are currently arguing in 3 cases that are pending before the Grand Chamber of the Strasbourg Court, the 3 cases on the Polish, Latvian, Lithuanian, and Belarusian border. I think they should probably be known. There'll be a hearing of them next February, high-profile cases before the Grand Chamber, but essentially they concern the situation at this border. And one of the points that we have been taking up there is that in such situations, evidently, procedures take place outside public scrutiny with asylum seekers often in very vulnerable positions, in often rudimentary conditions, and in particular, the absence of legal aid is one of the factors that has led us to conclude that there were indeed violations of Article 13 of the European Convention on Human Rights. And such a conclusion would most probably be even more easily reached when you look at the EU law provisions that are applicable in such situations. So the overall concern there is to create what scholars have called an out-of-mind, out-of-sight situation where the asylum seeker is out of the public eye and many violations go unreported. And I should also say that UNHCR doesn't always have access to such border areas. They're sometimes intentionally limited. Time limits for the applicant, that has also been quite a concern. It was mentioned they are under the new APR very short, potentially in some situations too short, and it will need to be seen whether that would then really be in line with the right to an effective remedy. But I like the reminder just now that, of course, all of these timelines are under Charter provisions, and there are still those references to higher ranking law, and the interpretation, of course, must be in line with them. And we have also seen judgments both from Luxembourg and Strasbourg that a couple of days for admissibility procedures and appeals there or lodging your application is too short. So we would hope this will be also taken up then not only by the courts but by the determining authorities. And my final point here is on judicial review of the pact, or what we might expect in terms of litigation and UNHCR's role there. Yesterday, it was voiced by quite a few colleagues that they expect that some of the new, and actually today also, that some of the new provisions will most likely be litigated. And I'd like to offer to the members of the judiciary here, but also to members potentially of determining authorities, our readiness to support in both stages. And that is not to attack a framework that has just been adopted in a very hard-fought compromise compromise, but to ensure precisely what we heard now, that all of these provisions must be understood and must be interpreted in line with higher ranking fundamental rights, be it the Charter, the ECHR, or international refugee law. And I'd really like also to thank here all the members of the judiciary and also the lawyers. Yesterday we heard from Valeria Ilareva the three cases on gender as a particular social group before the Luxembourg court. Very, very important cases. We were involved in all three of them. And we'll be watching the implementation of these very closely. And very finally, and perhaps this is a nice connection also to the previous intervention, we often don't even need to stray very far into lofty human rights principles in order to implement those rules properly. We don't need to invoke principles of proportionality or arbitrariness or like very vague notions. We just need to hold the regulations accountable for what they refer themselves to, and that is non-refoulement, right to an effective remedy, right to family life, the best interests of the child, the right to dignity. It was mentioned yesterday that this is something the Court of Justice refers to much more. So all of these rights are specific and guaranteed by the Charter, and they have been really crucially developed in recent years. And to ensure that secondary legislation is in line with them is not just a legal like evidence, it's also just to ensure that EU member states abide by the very rules-based legal order that the EU is and that they themselves gave themselves. So it's holding us and administrations accountable to the rules that they themselves developed. So with that, I'd end. Thank you very much and looking forward to a discussion.
Thank you very much. Indeed, it's time for discussion with the audience. We are almost on time, and we have now around 40 minutes for questions and comments. And as usual, I propose to look at the persons who are following the conference online to see there if we have hands raised, and well, it is the case. Apparently, we have two persons already willing to take the floor.
Hi, good morning. Do you hear me?
Yes.
Okay, perfect. Thank you so much for all the panelists. And I would firstly like to concur with the remark of Mrs. Baxewanos that she made in her opening statement, that it's about people. It is indeed something that is very important to keep in mind. That being said, I have a question for Professor Wedstedt Hansen on the harmonization of recognition rates. Currently, ECRE describes this as an asylum lottery, which I totally agree with. And I wonder if you see any mechanisms in APR that would lead to a harmonization of these recognition rates. I fail to see them when reading APR. And secondly, in the more pessimistic scenario that Professor Thiem discussed yesterday, would it be possible that we see a decrease in the overall recognition rate among EU member states in order to force these nationalities in the asylum border procedure? Would it be possible that national determining authorities under political pressure might start giving less protection in order to get to this sub 20% threshold? It's a very pessimistic reading of a possible reality, and I wonder how you see this. Thank you.
Thank you very much. Second person online.
Good morning. My name is Amanda Bisong from ECDPM, and my question is directed to Professor Chatel and all other panelists who would like to respond. So I'm listening to the presentations from yesterday and the presentations from today, and I think pushing the discussions to an extreme situation, I would probably draw the conclusion that international law is dead or in coma, with also what we're seeing in Gaza and what we're seeing in the EU now with regards to international refugee law and the measures that are being put in place to try to undermine or skirt about the provisions in international refugee law. And my question then, a bit being a bit provocative, would be why bother trying to maintain some of these standards if we see that at the end of the day, the push is to go towards almost automatic denial and inadmissibility, quoting the words of Professor Chatel. How do these align with EU values? How do these align with international refugee law commitments? How do these align with international law commitments in general? And trying to also look at the pessimistic scenario that was painted yesterday. What can we see moving forward? Is it going to be a Wild West where countries determine what they're going to implement? And why bother then investing so much into crafting these regulations if at the end of the day the focus is towards inadmissibility and automatic denial in some cases? Thank you.
Thank you very much. It seems that we do not have more questions online. No, so we can then turn to the room here. Just ask, raise your hand, and you will receive the microphone. Elspeth?
Good morning, good morning. And I enjoyed all the presentations enormously. I think, Jens, you did a brilliant job of trying to bring us back to whatever the purpose of this is. But I wanted, and I hope this is permissible, to ask a question to the discussant, Mr. Bombois, because we're now becoming awash in all these Latin terms. And I'm wondering whether the reference in Article 68.3 of the regulation to ex officio is a misinterpretation of the court's use of proprio motu. But I wonder whether what would you see as the difference between those two? Because one seems to exclude the legal effect. Ex officio seems to provide courts with an exclusion, whereas the court's case law seems to indicate an obligation to take into account a matter which has not been raised by the parties.
Thank you. Another question, Taylor?
Yeah, thank you very much, and thank you for your brilliant presentations. I enjoyed them very much. I would like to ask you a question on, as several of your presentations touch upon the concept of safe third country. I was interested in this new article, in Article 59 of the APR regulation on safe third country, the paragraph 7. As you know, it says that, well, the Union has concluded a formal international agreement with a third country by which migrants are admitted and they are protected in accordance with international standards and no refoulement, there would be a presumption of safety for that country. And apart from being quite dubious or finding controversies to accept this presumption, my question is that I would like to ask you about your views on a recent judgment that I think can be connected to this case, which is this, I'm sorry for the pronunciation, Elliniko Symboliou. Well, a judgment, a Greek preliminary reference that was solved by the court at the beginning of October on the possibility to apply safe third country for Turkey when Turkey has suspended the readmission agreement since 2020. And so my question would be, as in this, it is true that the Court of Justice says that the directive on asylum procedures, which is currently in force, does not oppose a member state legislation from designating a third country as safe when that country has suspended a readmission agreement. So it is not related to the designation itself, but in practice, the member state has to reject inadmissibility and examine the application. And I'm interested particularly on the argument by Advocate General Picamae. In that case, said that readmission would not be a condition of validity for the designation of a safe third country, but of enforcement of the decision. So, and I arrive. My point is, if this is concerned with enforcement and suspension of a readmission agreement is only relevant at the enforcement moment, the conclusion of a readmission agreement is not relevant for designating the country as safe, but it would be only to be taken into account when enforcing the inadmissibility decision. So I would like to know if you think I can sustain my argument and so have grounds against Article 59, paragraph 7 of the regulation. Thank you.
Thank you very much. Let's take one last question and then have answers from the panel.
Thank you. I have a short question, more practical question than a legal analysis to all of you, especially to Vincent. Thank you, by the way, for the excellent analysis, all of you. Vincent, you said that this is the new normal, the border procedures. I really shared the view, but I talked to several persons here and they said, we don't change anything. We have our border procedure, our airport procedures. Germany, we in Austria say we have our airport procedures. We don't change anything. Do you think it will be a real change, or will it be visible when member states have to submit their implementation plans, if they really create new facilities, or if it will be the new normal, or if everything will be running as it has been running during the last years? Thank you.
Thank you very much. So let's go ahead. I noticed one question for Jens. I think 2 questions for Thomas Bonboin, and then a last question for Vincent, but of course the other panelists can intervene if they want to add something. Please, Jens.
Thank you. I'm afraid I cannot answer. I understood the question to be whether it's likely that harmonization of recognition rates will become more effective under the asylum procedure regulation. And I mean, this goes back to the initial aspirations of the Commission, in fact, to have a truly common procedure, ensuring full convergence and so on across member states. And as I mentioned, there are factors pointing in both directions. I mentioned as one factor enhancing harmonization, which would ultimately also sort of increase the harmonization of recognition rates. I mentioned the interaction between the pre-screening at borders that may potentially merge with asylum border procedure. That in a purely procedural sense seems to most likely enhance the degree of harmonization, but it may at the same time actually decrease the harmonization of recognition rates, because member states will de facto become, if they decide, if they opt for this more or less clear merging between the pre-screening procedure and the asylum border procedure, and even the asylum as a return border procedure, that may then sort of put a lot of decision-making into this more or less black box where we will have uncertain procedural guarantees, no immediate right to suspensive effective appeals. And that may ultimately result in actually enhancing the differences in recognition rates. So again, there is no clear answer, but certainly not also any guarantee of increasing the similarity or harmonization of recognition rates. I didn't really get your question or remark about the acceleration ground on average recognition rates, but I took you to be skeptical, and so am I. I already indicated this. I think it is a strange novelty. In fact, we for many years had the acceleration ground of safe country of origin, which seem to be sufficient here and imply far more individual safeguards. The problem is that the new acceleration grounds pretend to have individual safeguard because there is a possibility to rebut the presumption of safety or whatever it be considered, but it doesn't seem reliable in the context of an accelerated examination, even in the asylum border procedure, that it should be possible to really in a reliable manner identify whether we have an individual applicant with a different profile than that sort of underlying the average recognition rate. So I simply consider it a clear risk that this pretended possibility to rebut the presumption on an individual basis is not going to operate in practice. So that was perhaps an additional observation in favor of your skepticism against this new acceleration ground. Thank you.
Thank you very much, Jens. Please.
Thank you. So the first question regarding the ex officio review. So according to the court's case law, this is an obligation for the judge to raise of its own motion any legal issue which can be relevant to solve the case at stake. That, say the court, on the basis of what it is contained in the case, of what it is documented by the applicant, and on the basis of the information that the National Administrative Authority has to recall to collect. That's the ex officio review obligation according to the court. And the second question regarding the Turkey as safer country. Well, I'm afraid that my duty of discretion is at stake here, of course. So what I could say, but of course, this is not a brilliant idea because this is obvious, is that what you mentioned, so the aspect of the Advocate General's opinion, is not present in the judgment of the court. It is not reflected in the judgment of the court. That will be my answer.
Maybe to start to the question also raised online, I will say that international law is not dead as such, and thank you for the very interesting question. Because, I mean, clearly, of course, when you are watching the news, looking at the social media, of course, that this is a legitimate question as such. Obviously, I'm used to say that violations are more visible than respect and implementation, in the sense that we should be careful about, first of all, the way mass media and public opinion are structured, focusing on Ukraine instead of Sudan, and so on. So there is clearly here a selection process in the type of information we are receiving. And second, yes, I mean, every single act we have done today are also a confirmation that international law does exist, in the sense that using emails, speaking online, and so on, be able to be there, because we are all, most of them are not living in Brussels and so on. So clearly, yes, international law is still valid for a large extent, but it's true also that it is more and more blatantly violated and more openly. So clearly, here, this has a lot to say with the political context, in the sense that now those who are against human rights, against international law, or simply against migrants are more vocal than ever, and they are more influential for many reasons which have nothing to say with international law. There is a dangerous racialization of the discourse of our society, and clearly extremism has an important role because we, the society, are giving them a role as such. And here this is a major issue in terms of when it comes to the respect for human rights, international law, and so on. So clearly, why maintaining these standards if they are violated? I think that then the question is relevant if we are living as if international law does not exist at all. But still, and the EU is a good example in the sense that the EU cannot say that we don't care about refugee rights. So, and clearly, this highlights another function of law. Law is not only the receptacle of values, it is also language, and it is also about how states are trying to pursue their interests in a broader framework. So clearly, international law is still, and EU law is still a broader infrastructure here to frame the debate as such, even if, again, violations are more numerous as such. So regarding the very interesting question raised by Paola under Article 79, paragraph 7, the short answer would, to me, given that Turkey has suspended, this paragraph is not applicable for me because the paragraph in question says that they have jointly come to an agreement. Coming to an so you can still say, okay, coming to an agreement needs not only to exchange ratification status and so on. The very fact that there is a suspension means that they no longer come to an agreement. So a literal interpretation of this provision can then put aside this issue in the sense that once the agreement is suspended, you can argue that they didn't come to an agreement in substance, so distinguishing the instrumentum from the negocium. So the instrument has been adopted and concluded, but the content of the agreement is no longer valid. So this is a way to, and I'm very shocked, I will say, by this provision, frankly, because they totally miss the fact that refugee law is not synalagmatic in the sense that this is not about a deal between two states. So you cannot just say, okay, let's we conclude an agreement to see, okay, you will be nice for refugees, and I can rely on these and send all of them to you. I mean, no. I mean, the duties of EU member states is not just put aside because they have concluded a treaty, in the sense that the substance of the duties are still there. So I'm very surprised how we can still have today this kind of provision as if it is enough to conclude, formally speaking, a treaty between two states to say that we are presuming that everything is going well without and accordingly discharging their duties towards the Refugee Convention, which is not a typical interstate convention. So clearly you cannot act like as if it is goods under trade law.
Thank you. Please, Fabian.
Hi, just a reaction to this very interesting question indeed. So it seems to me there's two steps involved. The first is a formal one, And that was the one that the court was concerned by, namely whether there is effective readmission or not. And as was mentioned, the AG's point has not been taken up. So the court, although it answered only the first question, I think it's very clear also from the answer to the first question that if there's no readmission for a long time and there's no foreseeable prospect for that to change, then there cannot be an inadmissibility decision. And that was really a no-brainer because that's what the APD says. The APD says that there can't be an inadmissibility decision if there's no readmission in the third country. So it wasn't surprising. I was actually more surprised that the case gained so much attention. I understand that Greece, Turkey, safe third country is very politicized, but the question in itself was actually hyper-technical. It was just a question of sequence. But anyways, so this is the first step where you check readmission. But the second question is what you raised on 59 paragraph 7. And that's more of a substantive assessment where you check if there is such a readmission agreement, is it safe? And I would maybe have a bit of a more nuanced view to my previous speaker, because this paragraph, although perhaps raises some problems, it does refer up to paragraphs 5 and 6 before, and the paragraph 5 before says that there needs to be a connection between the applicant and the third country, and it requires an individual assessment of whether the country is safe. So despite an agreement, it is not just an automatic rejection. And of course, we can discuss how things then look in practice. But if there would be such an automatic rejection mechanism without checking the individual case, this would be a breach of this provision. The provision itself is relatively clear that there still needs to be an individual assessment with all the conditions in place and a connection.
Thank you very much. We still have 15 minutes for a second. You want to say also something, Barbara? Okay, sorry, thank you.
I'd like to answer to Ulrika's question, or comment. So I am also skeptical about the will of the states. All states are supposed to prepare their national implementation plans, and there is a special technical support instruments, and only 9 member states response to the call of the European Commission. So there were Belgium, Czechia, Germany, Estonia, Greece, Ireland, Italy, Portugal, and Romania. And they asked for expertise from experts. The rest of the states were not interested in expertise. So who knows, maybe everything will stay as it is. So thank you.
Thank you. Jens, you want to add something?
Yeah, just an additional remark or observation on Article 59, paragraph 7. It may, at first glance, seem to be a kind of EU-level Lex Rwanda or Lex Turkey or what have we. But importantly, it is presupposing that there is an agreement pursuant to Article 218 TFEU, which was not the case with the EU-Turkey deal in March 2016. Yeah, I'm aware of that, but still, I mean, this relates to the consideration of the country as a safe third country, and that would seem to be, on the one hand, recognizing that maybe there was uncertain basis for the EU-Turkey arrangement in that regard, while at the same time then at least presupposing that there is an agreement which also then relates not only to readmission but to the quality of protection in the third country in question, I would assume. And then an additional remark, I think what Vincent said a few minutes ago was extremely important and maybe one of the sort of the core issues in the debates likely to come up about the future concept of safe third countries. That is the scope of international treaty obligations that will have to be taken into account. And that's where I think maybe the sort of the basic or fundamental legal positions may end up in respectful disagreement, because I would agree with Vincent that the Refugee Convention does have some bearing on pre-procedure returns to third countries, presumably safe, towards anybody who has been within the jurisdiction of a refugee convention's party state. But apparently already now the asylum procedure regulation presupposes that this is not really the case. I mean, the definition of the notion of effective protection seems to presuppose that it can be applied to non-parties to the Refugee Convention, regardless whatever obligation the EU member state may have under that convention. And that I think will be the interesting disagreement to be pursued, and maybe a crucial one actually to the future delimitation and application of the concept of safe third country via this notion of effective protection, which is just underpinning the safe third country notion.
Thank you. Let's use the last 10 minutes to do a second round of questions. Let me first ask if among the 172 persons following us online, if there is one question before then, asking the room. Nobody is raising an hand. No. Yes, please go ahead.
Yes, hello. Thank you very much. I'm Christophe van Emerijk. I'm from the Belgian Federal Migration Center. I had a question with regard to the EU-Turkey judgment. So,
can you please turn camera?
Sorry? I cannot hear you, but I'll ask my question. I cannot hear you very well. But basically, my question is, when I read the judgment, I saw that the court kind of interprets the safe third country notion, referring also to Article 18 of the Charter, in the sense that it says that this notion is an implementation of that right. So my question is, what is going to be the future relevance of Article 18 of the Charter in the interpretation of the pact instruments? Thank you.
Thank you very much. If there are no other questions online, it doesn't seem to be the case. Then we turn to the room, and I saw that Bordizar has a question, and there is another one later on, please.
Thank you so much, Bordizar. And it was definitely worthwhile to get up early morning to listen to this panel. I thank you for that. My question is addressed practically to all the members of the panel, and it relates to border procedures which are conducted on the merits. And the essential question combines recital 66 and 68 of the regulation. 66 says that certain facilities may be at locations with difficult accessibility. If you have a procedure running till the end on the merits, and that includes appeals, and it might include as reflected in recital 68, that means that the court procedure, the appeal procedure in front of the court, is within the border procedure in facilities which are difficult to access. So how would that happen? Look, if you want, the first question is, do I understand correctly that in some cases the appeal procedure is within the border procedure? So the court procedure should be conducted while the person is in the border procedure. Second, how is that done in respect of facilities which are difficult to access? Thanks.
Thank you. There was a question there, Tamas.
Thank you, Philip, Mr. Chair. Good morning, everyone. My name is Tamás Molnár. I'm with the EU Fundamental Rights Agency. Thanks a lot for this highly illuminating discussion. I've very much enjoyed all contributions. My question concerns enforcement. enforcement of this new corpus juris governing asylum in post-mid-2026 legal landscape of the European Union. Besides the already existing classical tools of enforcing EU law, like the infringement procedures to be initiated by the Commission, horribile dictu by member states, or the EU pilot procedures and other stuff, what kind of other ways of enforcement can you envisage to make this huge body of law a reality? Since we've seen significant reluctance from member states to implement, and also after Article 260 TFEU procedure, when the Commission had to go back before the EU Court of Justice against an enfant terrible member state who hasn't implemented at all a Grand Chamber judgment finding infringements of serious importance. So apparently there's a lack of good faith in some corners of this block of 27 members, and how to, let's say, make sure that this body of law is implemented, perhaps through some other softer forms of implementation. Look at the Common Implementation Plan, the National Implementation Plan, all this Soviet-like paperwork attached to the regular and recurring projection of national implementation, national strategies, EU-level reports, and 5-year EU migration and asylum strategy. So, and if you can see softer forms, what softer forms might achieve the goal? Thank you for your reflections.
Thank you, Tamas. One last question. Nobody in the room? Yes?
Hello, good morning. My name is Zuzana Pavelkova. I work for Organization for Aid to Refugees, which is an NGO based in Prague, the Czech Republic, and we provide legal aid and legal counseling. And this is also where my question goes. I was wondering really about the notion of entrusted persons who would be allowed to provide legal counseling to several persons at the same time. The way how our government is interpreting this is that group counseling would be essentially allowed. Whereas when I read ECRE's comments on the APR, ECRE is saying that the APR does not allow for group counseling because the notion of group counseling does not appear in the regulation. So my question is group counseling now allowed or is it not? Our government was also mentioning 2 weeks ago that in some member states, group counseling is already taking place. So that's my question actually to the room. Are there member states where group counseling is already taking place? And if so, what are maybe some of the guarantees which should happen? Because I can imagine, taking one family as a group, but I cannot imagine taking 50 people as a group and providing counseling to them in a way which would really ensure the quality and also confidentiality of the counseling. Thank you very much.
Thank you. Well, it's 11 o'clock, so we should now give the possibility to the panelists to answer. May I all of you ask to be brief, to go straight to the point in order not to have a too short coffee break. It's not always easy. One of the questions were addressed to one person, but not all of them. So I propose that you pick and choose the question that you want to answer. And let's start again with Jens then.
Thank you. I am convinced that my colleagues are better placed to answer these questions. They were quite specific, so I think I'll refrain and facilitate access to coffee.
Thank you, Vincent.
Same.
Okay, Barbara, there was a question about group counseling. You cannot avoid to answer that.
Quite difficult to answer because of the diversity of states' approaches to legal advising. As for now, in the first instance, there is no requirements of counseling. So today there is the requirement of just providing legal information, what can mean everything. For example, just providing just leaflets about with the information and maybe the telephone number to the NGO, and it's enough. So there is still the case of the future, but I think that introduction the untrusted person is quite dangerous. I think that it will be used in the case of the big or massive flow of refugees. At that time, this group counseling probably will be quite common. But well, I don't know how it is in various countries with the group counseling. Is the question to the audience. Thank you.
Thank you, Fabian.
Thank you very much. Some very good and very difficult questions. I think on Article 18, the previous speaker is going to be better placed, but just to say that there is loads of PhDs written on that, and it ranges from an interpretation of it only means essentially non-refoulement as per the Refugee Convention to it could mean actually the right to a correct status. And we have one case from many years ago where the Court of Justice said something about if wrongly subsidiary protection status is granted, that could be a violation of Article 18, on which some scholars have jumped. But I think this is to be discussed, and I'd be curious to hear what you think. On border procedures and court hearings, yes, the border procedure shall last no longer than 12 weeks, including appeals. So that includes the appeals. And how would that work? Either by video. There is in the APR the option of video conferencing, so essentially remote hearings, and conditioned by if that is possible, if the arrangements can be made. Not sure, in those difficult to access locations. And if not, then a person can also be allowed to travel to a court hearing. But if I understand well, the fiction of non-entry would then travel with the person. So if the person travels to a court to be heard, he would or she would still not be considered to have entered or be authorized to enter. And then lastly, on enforcement, it's a bit of a self-interested question because, of course, the Fundamental Rights Agency will have an important role to play there. I think it can range from everything from monitoring, guidance, case law summaries, up to really then imposing very high fines to the enfants terribles, as you mentioned. So yeah, it's a long discussion. Maybe we can discuss over coffee. But thanks for that.
So, and then logically, the Court of Justice will have the last word.
That's how it works. About Article 18 of the Charter, I won't say much more about that article because, of course, the Court of Justice case law about that article is a work in progress. But I cannot exclude, certainly not, that some national jurisdiction will refer to the court preliminary rulings not only on the interpretation of the new procedure regulation, but also on its validity. And of course, in that case, Article 18 will play a fundamental role in the court assessment, but not only Article 18, as I said, Article 18 has to be read in conjunction with Article 52 of the Charter, which authorizes under some certain conditions limitations to all the rights enshrined in the Charter, also the right to asylum guaranteed by Article 18, so Article 18, Article 50 of the Charter, but also, of course, the Geneva Convention, which, according to the constant case law of the court, is the cornerstone of the asylum system in the EU, and the analysis of the UNHCR, which is fundamental for our case law. Thank you.
Thank you very much. Thank you for to all the panelists for this first morning session. And now I think that a warm coffee is waiting for all of us. We come back around 11:30 for the last session.